This course serves to provide a baseline understanding of copyright and content ownership. I've written my paper, but who technically owns it? Authors, and in some cases their employers, have the right under national copyright laws and international treaties to control how their works are to be used and distributed to others. This statement is a fact. Authors, and sometimes their employers, if the author and employer have an agreement in place as part of the author's employment, retain the rights to the use and distribution of their works under national copyright laws unless they sign away those rights. Copyright protects the underlying facts, the idea of your work, and the way you express your thoughts and describe your research and conclusions in your writing. This statement is a myth. Copyright only protects the way in which the ideas or concepts are expressed, not the underlying facts themselves. Someone else could describe or express some facts or results in a different way from you, and that would not be considered a copyright infringement. The extent of copyright rights allows authors to permit the copying, distribution, online access, translation, and creation of other derivative works of research. This statement is a fact. The extent of copyright rights does allow authors to permit all of the following: copying, distribution, online access, translation, and creation of derivative works. This is a myth. Publishers do need written agreement from authors to be able to distribute the author's work. The extent of copyright rights does allow authors to permit all of the following: copying, distribution, online access, translation, and creation of derivative works. This statement is a myth. Journal publishing agreements usually spell out the rights that are transferred to the publisher as well as the rights retained by the author. Publishing agreements also usually include author warranties. Generally, these are statements that certify the work was created and conducted in an ethical, compliant manner. There may also be certain special provisions for government works. For example, U.S. government works are to be in the public domain. UK government works are to be owned and licensed by the U.S. government. Rights retained by authors are spelt out in the publishing agreements and typically address academic usage rights. Use of the work in an author's teaching. Reuse of the work in other scholarly works. It is important to note that publishing agreements vary by publisher, so they should be carefully read. Publisher agreements do vary, and less restrictive terms do apply to those Elsevier titles that are published open access. In Elsevier's case, though, our author agreements allow the following: copies of the article for classroom teaching, articles to be included in course packs for educational purposes, copies of the article for sharing with fellow research colleagues, copies of the article for those attending a meeting where you are presenting the article. Article can be expanded to book form or used in a thesis dissertation. Article can be used for any patent and trademark rights. Publishers also typically spell out posting allowances for authors. In Elsevier's case, we allow posting of preprints to internet websites, including preprint servers, posting of a revised personal version of the text of the final journal article to reflect changes made in the peer review process to the author's personal or institutional website or server, posting in accordance with agreements made between Elsevier and funding bodies such as the Wellcome Trust and HHMI.